Today we are going to discuss Section 3 of the Probation of Offenders Act, which in total consists of 19 sections. We'll just understand the first section. So before we get into the Act, it is important for us to understand the general meanings to the term. One is probation, other one is admonition. These are the terms which we usually come across very often in the Act. Probation. When we talk about probation, it's a term which is used in our day-to-day life. It is used in a workplace. In a workplace, usually colleague says, I'm on a probation period. I'm on a probation. That means where they are on a temporary training period. But in the law, it has a different meaning. In a law, it is a time period in which a person who have committed a crime, instead of sending him to a prison, he will be released, saying that he is to obey the law, and at the same time he is going to be supervised by the probation officer. The next question is here, what do you mean by admonition? Admonition is nothing but releasing a person who have committed an offense without sentencing him for the punishment. Now, getting into the main act. So speaking of the main act, we do have this release of offenders on probation or admonition. They'll ask you a direct question. Discuss the release of offenders on probation or admonition. This is a direct reference to Section 3. So when we talk about Section 3, Section 3 of the Probation of Offenders Act 1958 deals with such provisions where a person can be released on admonition instead of sending him to a prison. Now, under what circumstances he can be released? Number one, what it says is if a person have committed any offense where he is guilt of Section 379. 379 deals with theft, punishment for theft. 380 deals with theft in dwelling house. 381 deals with theft by clerk or servant of property in possession of master. And 404 talks about the dishonest misappropriation of property possessed by deceased person. And 420 deals with cheating and dishonestly including delivery of the property. If any person have committed any offenses which is covered under these sections of the IPC, or where punishment is up to 2 years. Up to 2 years, it should be less than 2 years, max is 2 years, and it can be with fine or both. At that point of time, a person will be released on probation, that is admonition, upon considering the following conditions. The court will consider the following condition. Number one condition that the court will consider is that the person should not have any previous conviction. That is, a previous conviction should not be proved against him. Number one point that the court is going to consider while releasing a person on probation. Number two point that the court is going to consider is if it is in the opinion of the court, if court feels that it is expedient is nothing but if the court feels that it is appropriate, at that point of time, the court can release the person on admonition. And upon viewing the nature of the character of the person, after considering these 3 points, the court may release a person on admonition, that is probation. Now, next, we are going to understand few cases so that we can better understand this concept of Section 3, probation on admonition. Number one case we have here is Anandan versus State. In this case, what happened? There was a petitioner who was accused for charge. He was accused and there was a person who was an accused. He was charged with Section 392 and 397. So 392 basically deals with robbery, and 397 also deals with robbery or dacoity with attempt to cause death. So the person was found to be convicted of this offense earlier. Later, when the court took this matter into consideration, it was proved there was already a conviction against a person, since this first point is not being fulfilled. The first point says for a person to be released on admonition, there should be no previous conviction. In this case, there was a previous conviction which was proved against the accused. For that reason, accused did not get the benefit of Section 3. And then there's a second case, Prem Ballab versus State Administration. In this case, the person was not released on admonition because the law says no benefit to be given to the Food Adulteration Act. Then third case, Dr. Jacob George versus State of Kerala. In this case, what happened? There was a doctor who operated a lady by using a scientific gadget where he was not expert, where he was not expert in that field of operation. Later, considering the view that the person without expertise operated a lady, which resulted in a failure of the operation, considering this facts, the court said person is not to get the benefit of benefit of section 3. And then we have Devi versus state of Haryana. In a Devi versus state of Haryana, what happened? There was a petitioner who forced the victim to render a sexual submission, to render a physical thing with commercial object. Later, the court said he was convicted for abduction, for which the punishment is 3 years. Where the law says a person to be released on probation, the maximum imprisonment that can be given to him must be 2 years. But in this case of Devi versus state of Haryana, the person was abducted, was charged for abduction, where the punishment was up to 3 years. So he was not entitled to get the benefit under Section 3 of the Probation of Offenders Act of 1958. And then there's a case, S.A. Roy versus state of Andhra Pradesh. In this case, the court said the petitioner in this present case was aged 50 years when the offense was committed. Therefore, the Probation of Offenders Act was not applied. So this is all about Section 3, Probation of Offenders Act. If you're looking for handwritten notes, typed notes, and classes, and if you have any queries, you can contact to the number given. See you all in the next video.